Hi, this is Ed Sullivan and Marco Berti talking about retaliation and the new wave of retaliation cases. And frankly, there's a new wave of anti-retaliation laws. Mark, we've heard a lot about Dodd Frank. It was a part of the election, the 2012 election, and it was discussed. Protects whistleblowers of some type. Explain exactly what it does and how it's basically the newest anti-retaliation law that companies have to be aware of.
Sure. Back in 2002, Sarbanes-Oxley was passed. It has a whistleblower anti-retaliation provision, and that's kind of like the stick. Well, now Dodd Frank, in light of the wave of bank failures and the whole economic collapse, was passed in 2010, and that uses the carrot. And the carrot is, employee, if you're at the company and you see some securities fraud afoot, and you report it to the SEC, and some other things happen, and the SEC ultimately prosecutes and has a recovery of over $1 million, you can get a percentage of that. In fact, you will get a percentage of it. It's called the bounty hunter provision of the law. So it's a carrot out there for employees that see security fraud afoot to make that complaint to the SEC, and they don't even have to go through the company internal procedures that SOX required them to set up. They're encouraged to, but they don't have to. So Dodd-Frank is really this carrot out there for employees to blow the whistle. Now, it also has a component as part of that of, if they do reach out to the SEC and make that complaint, the company can't retaliate against them. And so there's some provisions of the law that are built around that. The law was just passed in 2010. There's been a handful of cases decided since then. And in our next component of this series, we'll focus a little bit more specifically on the anti-retaliation provisions of Dodd-Frank and why they're so much more threatening even than Sarbanes-Oxley to companies.